All right. So thank you everybody for showing up today. I'd like to discuss private equity transactions in the dental practice space. And I'd like to go through not only sales of practices to private equity groups, but also interactions between dentists who are looking for work as an associate or an independent contractor, and then also the investment opportunities that a dentist might be approached with into a DSO or a private equity partner. And so I'm an attorney at Wood & Delgado. I'm a partner, and we are attorneys, advisors, and consultants in the legal space. And we talk to our clients about business issues as well. We work with dentists throughout the United States. We're based in California, and we hold licenses also in Colorado and Texas. As a disclaimer, the information shared during this webinar is meant for informational purposes and does not constitute legal advice, nor does it form the basis for an attorney-client relationship. If you're considering a business transaction, you are advised to retain an attorney to represent you during the course of that transaction. Again, my name is Justin Morgan. My educational background is I went to UCSB and graduated in 2011. I graduated from USC in 2011, and I externed for the Ninth Circuit Court of Appeals in Reno, Nevada for a summer, and then worked as a commercial and bankruptcy litigator for 5 years, 4 of which were with an international big law firm. And then I decided to move into the private practice healthcare industry, and I spent some time at a lender learning how to finance acquisitions and how banks look at risk. And now I have leveraged that background into providing outside general counsel to my clients and also working on mergers and acquisitions throughout the country, in addition to partnerships, buy-ins, and all sorts of business transactions that dentists get into. Now to start, I'd like to talk about DSO associate agreements, right? And so one thing that's really important to understand and think about when you're considering working for a DSO is whether that DSO is established as a corporate entity, right? We have DSOs that are popping up all throughout the country as more corporate players get involved, and also as doctors start to expand their practices, right? And so that's going to be important because you want to know whether that's an experienced potential owner or employer that understands what's happening and understands the needs of the dentist and also the patients, or whether you could be exposed to some risk as they learn how to operate the business and grow it from an inception point. And the other piece is how established is the practice at which you will be working, right? And these are important questions to ask the representative of the DSO, because sometimes we see associates basically starting a new location on behalf of the DSO. And if they're paid based on their compensation or based off of their billings or their collections, that could be very detrimental to their bottom line, right? Because when a practice is just getting going, there might not be a ton of dental work to be performed, which actually draws down the associate's potential compensation. And likewise on the other end, you want to know what your work schedule is going to be and how much revenue for which you will be responsible. And so if you jump into an associateship at a location that is doing maybe $1 million to $2 million a year, and you're replacing a strong associate that was generating quite a lot and working 4 to 5 days a week, you can be fairly assured that you'll have plenty of work to complete, and your compensation will follow that. But if this location has been dwindling over the last couple of months without an associate, and there are weak employee issues there, right? If there's half staff or a skeleton crew manning an operation, then it might take a while to get that location up and running. And you might even feel pressure from the DSO to produce and grow the practice, even though you might have been just hired to act as an associate and manage the clinical care. with everything, location matters, right? And so you want to know which location you're going to be working at, because often DSOs will have multiple locations and they may ask an associate to start at one location, but to transfer to another. And that can be detrimental to your work schedule, your travel schedule, and your personal time. If that second location is, say, 30 minutes away. And these issues matter because some of these DSO agreements are pretty sticky in terms of whether a person can get out of them and whether that person retains an enormous amount of control over where they want to work. And so you want to be careful that when you view the contract as a whole, that the dentist or the contractor is not going to be in a challenging position in which they're forced to change offices and they can't get out of the contract because of, let's say, arduous termination rights, right? And so that's another thing that comes into play when we look at contracts on behalf of our clients. It's how can our clients get out of this contract and what are the costs going to be to them, okay? Going down the list, there will also be certain duties that may be assigned in an associate agreement, right? So sometimes you may have clinical responsibilities only associated with the BSO agreement, but sometimes there might be some management duties that are responsible that the associate will be responsible for as well. And that's really going to be reflected in the conversations and understood in the conversations with the owner of the actual practice or with the representative of the DSO. It's really important to ask those sorts of questions because you want to be, or the associate wants to be well advised, okay? And then obviously the big one is compensation, as it always is. The associate would want to know whether they're paid a salary, whether they're paid a per diem, how long the per diem is going to be paid, how are they going to be compensated based on collections or net adjusted production, and whether any bonuses are going to be offered, right? And so be wary of offered bonuses that are unattainable, right? We see it every once in a while, but that's why it's really important for the associate to speak with the owner or the representative and set expectations so that no one is let down or has high expectations when those aren't going to be met. Additionally, what we see when we're talking to DSO and larger private equity backed groups is that there might be some additional compensation that is provided to the associates, whether that's a retention bonus, a yearly bonus, or a relocation bonus to make the contract a little bit stickier. Now, on the front end, it can be great because that bonus can be $10,000 or it can be $5,000, but it may come with some pretty significant strings, which means the DSO is going to require that person to work for at least 2 years, or that bonus might be subject to recoupment. And that's a tough pill to swallow when you basically spend a retention bonus and you have to pay, you get paid only a portion of that after taxes have been deducted. And then when you leave, you have to pay the full balance and then try and get that deducted from your taxes on the back end. So that can be relatively challenging, especially if the terms and the reasons for leaving the practice were because of a lack of income. And also mind the benefits that are associated with these sorts of agreements, whether vacations permitted, whether there's business expense reimbursement, if you're going to be, acting as the manager, if you're going to be acting as, the business development officer for that group as well. You want to make sure that all of those things are going to be in line with the actual agreement and the responsibilities that you'll have. Additionally, what's really, really important are termination rights. I mentioned it before, but sometimes we can see the DSOs come in and have really, really strong or difficult termination rights on their behalf or against the actual associate. So sometimes you'll see 90-day termination windows, and if the associate leaves before that, then they'll be charged a certain amount per day. Sometimes you'll see the DSO having absolute termination rights with no notice to the associate. So you want to make sure that we try to rectify the balance. And what's important to understand is that CSOs and their attorneys are often really sophisticated, and they may be operating under a different set of rules than, let's say, an attorney that's representing a solo owner, right? Because when you're working with a multi-million dollar client, those there sometimes can be more of an emphasis on scoring wins and really drafting the agreements so that they heavily favor the DSO. And so it's important to keep an eye on that. And if someone ever says, hey, this is not subject to negotiation, I would still press back and attempt to negotiate and speak with an attorney just to kind of press, because almost everything is negotiable and you should at least take a run at it. Now, restrictive covenants are critically important in negotiating with DSOs. And this is another thing that comes into play when you're negotiating with a sophisticated counterparty that has a lot of leverage. They're going to ask for restrictive covenants that truly benefit the DSO. And what that could mean is that the restricted covenant radius could be imposed on each of their offices in a general location, or each office at which the associate works. And so what we try to do is we try to get those restrictive covenants reduced down to a reasonable amount so that the associate isn't basically barred from an entire area in the state. And finally, dispute resolution. This is sometimes negotiated, but not often. Dispute resolution is the obvious, it is the process by which disputes between the associate and the owner are resolved. And so what that means is, are we going to court? Are we going to mediation? Are we going to arbitration? In certain circumstances, court is preferable, right? So if you have, basic heavy fact-based claims where you have emotions involved, you have people that have been harmed, court's going to be a better place for the aggrieved, right? Because the jury awards can be higher, but if you're dealing with a strict breach of contract sort of issue, an arbitration or a bench trial might be more appropriate, just to get the issue resolved as soon as possible to stop the bleeding between the parties regarding attorney's fees. Now, the second piece that I'd like to discuss today is DSO investments, right? And so we have a lot of clients come in at the firm and they're looking at the opportunity to invest with the DSO. So they may be approached with the opportunity to say, hey, you can work here, and then you can also invest $50,000 or $20,000 and buy stock in the company that can generate you returns over time. Now, the most important thing here is really talking this through, if not with an attorney, but certainly with a financial professional, right? And so you want to understand the terms and want to understand what you're actually buying. And so I've had a couple of clients who have kind of bought sight unseen, and they buy on this dream that they're buying some piece of a dental practice or a DSO that's going to give them pretty good returns on their money. And without having an adequate financial advisor or someone really going through those details, it can be hard to determine whether that's going to be a good investment or not. And sometimes we see the DSOs submit pro formas, right? Which are forward-looking financial statements about a projection that may or may not occur. And so if they're projecting that the company will make X amount of millions of dollars in profit in year 5, and something happens between year 1 and year 5, you could have basically bought worthless stock that is not going to return you what you thought it would. And if you don't take that and compare it to what you reasonably believe you can get in another investment, you might end up on the losing side of that. And so it's important to understand what the business proposition is, what the likelihood of success is, and then also what your return on your investment is going to be. And one of the things that we see when we're looking at these sorts of investment deals is that if the investor wants to get their money out, it can be limited to certain time limitations, certain authority, like they have to have approval by the company, or the valuation for their investment can be set by the company in its reasonable discretion. And so if you're dealing with a $40 million company that has $40 million of revenue, and you want to contest whether your stock that you've invested, 3 years ago is worth 75,000, or if it's worth $85,000, it's going to be really hard because you won't have a ton of leverage to negotiate against the company. And if they acted in bad faith, you'd ultimately have to sue them over something that is pennies to them, but extremely valuable to you in terms of the cost, right? So, a $10,000 loss for the company is nothing, but a $10,000 loss to an individual investor means the entire, it's a very substantial. And so you want to understand the balance of the equities and the balance of power when you are negotiating those things. In addition, there could be penalties associated with leaving the investment too early, or actually leaving the associateship too early. And you also want to make sure that there aren't additional covenants or restrictions in the investment documents that impose greater restrictions in the associate agreement. And I had a client who was effectively barred from 2 Midwestern states by the investment documents that he executed when he purchased or bought into this DSO. Now, we were able to negotiate an exit from that and get him protected so he could move on, but it certainly was a concern, and it caused him a little bit of concern and legal costs to get out of that. And so the final major topic that I want to touch on right now is our DSO sales, right? And so throughout the country, everybody's aware that DSOs are growing in size by acquiring practices throughout the country, right? And so the concept here is that these are businesses that have sophisticated people behind them that are basically taking a look at dental practices and saying, look, these are profitable groups. If we structure a deal a certain way, we can be relatively certain that we'll have a good return on our investment, and we can go ahead and continue to make money from that. And everybody's got a different philosophy. And so you have a lot of groups out there, and they're all basically coming up with their own business case and their own method of offering compensation to practice sellers, and also establishing partnerships. So some will want the seller to stick around for 1 to 2 to 3 years. Some want the partners to be available and around for 10 years. Some will pay a high amount of cash up front, and others will pay a moderate amount of cash up front and then term out the rest of the cash subject to certain contingencies and financial metrics being hit by the practice owner. And so really understanding the structure of that is really important. And it's also really important that an owner doesn't just take one offer and run with it, because with one offer, you don't know whether you're getting the best deal out there. It's important to solicit other offers and see and be able to compare those, because they're going to be really different, right? If you've got, and this is a common issue that we see on the market, in which a DSO player is going to come on and say, I will pay you 12 times your EBITDA multiple for your practice, right? But in reality, they may end up paying 6 times EBITDA up front, and they may pay that owner a reduced salary or a reduced percentage of their collections over the earnout period, so that basically they're paying what a private buyer would pay. And so it's really important that we don't get confused by how the deal is structured and avoid a potential private buyer that may ultimately be cleaner. And so in terms of private sales, we often see that these are deals that are done at closing, and that the owner is able to walk away from the practice right afterwards and is not required to stick around. And that can be really valuable for a retiring doctor that doesn't want a ton of obligations, but may want to potentially practice 1 day a week or retire immediately on closing. And so that's that, being aware of that and being ready for that. If you are a seller, and understanding what the obligations would be if you did want to pursue a DSO partner, it's going to be important to be ready for that psychologically and from a work schedule basis. Now, in the third tab, we talk about EBITDA multiples, or the third, when we talk about valuation, there's EBITDA multiples. And what EBITDA is, it's earnings before interest, taxes, depreciation, and amortization. And so if you understand what a profit and loss statement is, you understand what the tax returns show, you're going to have from the top to the bottom, you're going to have revenue and then all of the deductions from your costs and expenses. And what EBITDA is, it's drawing out interest, taxes, depreciation, amortization, because these things are going to be unique to that specific owner rather than, and they can be subject to change when you take over the practice. And so it's in the easiest way to put it, it's a corporate manner of comparing apples to apples. So each of the financial professionals will draw out those 4 items to try and understand what the real profit to them will be. Now, when we talk about profit to a corporate owner and profit to an owner, it's very different because the actual owner typically will work in the practice and pay themselves 30% of their collections or a portion of what they produce. And so that's going to be different when we talk about owner profit versus EBITDA, which is going to be a much smaller number, right? So when we talk about $1 million practice, let's say that we have about 60% of that is overhead, and then 30% goes to the owner, right? The last 10% would be something like EBITDA. That would be the profit to a corporate buyer. And so when they talk about a multiple on EBITDA, it's going to be the multiple on that, right? Now, when we talk about multiples on a private sale to a seller, it would be EBITDA plus what the owner takes home, and that would be the owner's profit. And then as practices grow, the owner's profit increases, but only it increases marginally after the owner has an associate that's performing the work. So if an owner generates $500,000 of collections for practice, and they have an associate that generates $500,000, the owner would take only the profit on top of the associate's work. And so that's what they're talking about when they're talking about multiples and how that's actually calculated. Now, when we think about what DSOs are interested in buying, they're interested in buying profitable businesses, right? And so it's important to understand that what's profitable to a dental practice owner might not be as profitable or sufficiently profitable to a DSO. And so often they're going to be looking for $100,000 to $200,000 of revenue, or excuse me, profit before they get interested, because they want that business to immediately return some money on their investment and fuel the continued growth. Okay. And so previously we'd also talked about payout structure. We talked about contingencies, and it's important to understand how that structure might or might not impact you. And to ground everybody on this, I had a phone call with a potential client at one point, and she had sold to a DSO who'd approached her about selling her practice, and she didn't she used a local attorney that was a friend. She didn't understand, how the payment structure could go really awry. And so once they took the practice over, she basically got 50% of what she thought she would get, because after they restructured the staff at the practice, revenues went down substantially, and then she lost the ability to actually produce enough to hit certain key performance metrics to be entitled to the bonus compensation or the back-end compensation. And that was very, very challenging for her, because she essentially lost all of the value of her investment in that practice over time and maybe broke even. And ultimately, I think she faced bankruptcy as a result of that. And so these are important deals to understand, and they take a high level of sophistication to get comfortable with all of the issues. And it also takes a high level of exposure to several different types of deals and players in this market, so that the client is going to be well advised and protected. Okay. And then in addition to cash compensation for a DSO sale, there's also sometimes going to be equity compensation. And so there can be a blend of cash and marketable securities or stock that's going to be paid to the owner. And again, now you have not only a sale, but you have an investment in a company. And so you need to understand how that company is run and where you stand in that company so that your investment is protected. It's really important to note that if you are a minority investor in a business, you're not going to have any power ever. And so it really needs to be a great deal for you to make up for that lack of power, right? And so it's something to consider. It's something to discuss with your financial advisor and people that care about you and your financial well-being, because there's risk associated with all business and there's risk associated with all investment. And the return, the potential and expected return should outweigh the risk, okay? I think we've touched on this briefly, right? But teamwork is important in any of these transactions, okay? I've got a couple examples here. The first is the practice owner that essentially sold to a DSO and wasn't entitled to any of the buyout back-end compensation because the staff left and they were no longer able to produce. And then I'd like to also talk about the very last one. And there's some groups that are out there that are offering a different style of compensation to associates. And it sounds really good and it will work for certain folks, but it needs to be fully understood, right? And that is the DSO can come in and offer a really high salary and say that this person owns the practice, but in reality, there's no right to profit because of the agreed upon DSO management fees that are subject to change at the DSO's whim. So while the owner may own the practice, they're not going to have any profit from it. And their ability to resell that practice is going to be limited by the terms of their agreement with the DSO. And so that can be challenging because those structures are creatively put together so that it benefits the DSO. And that's really why you need to have sophisticated counsel and a sophisticated financial advice to be able to work through those issues and make sure that it's good for you, right? There's never going to be one size fits all, but you want to make sure that the shoe that you do put on does fit, okay? All of that being said, thank you for your time today. You know that it's the middle of the week and everybody's tired, but again, my name is Justin Morgan. My email is justin@dentalattorneys.com and my cell phone is 213-369-8698. And so right now I'm happy to open it up to questions. And if people want to reach out and reach me independently, I'm happy to have conversations as well. So it looks like we don't have any questions today. So I'm going to let everybody go. Again, you can reach out independently and we can have conversations about questions you have. And I hope you have a great Wednesday afternoon or evening. Thank you.